I welcome you in the fourth lecture of fundamentals regarding the legal compliance for incorporating startup. And in this lecture, I will more concentrate on comparative analysis of incorporation cost or compliance cost. Until now, what I did, I told you about what are the business form, and then I talked with you regarding comparative compliance requirement for different business form. And now I am going to talk about that what are the cost you require to incur while incorporating your or registering or forming your startup organization. And as I have told you in the last case that compliance should also be one of the criteria for your decision of choosing the business form. Similarly, the cost for forming the business form or choosing the business form should be another criteria for your decision making of choice of business organization in the beginning of your startup or when you are starting your startup. Now, again I put it into a tabular form. In the right column you will find I have named the type of business form, like I have named it proprietorship, partnership, LLPs. And in the other, from left to right, I put another 3 column, and the first one is relating to pre-formation documentation cost. Then the second one is minimum capital requirement, and third one is filing cost. Now, if your business form is simple, you incur less cost. If your business form is formal and more formal, then you incur more cost. But at the same time, if you remember my first lecture, I have said in some of the segment you do not have much choice relating to the form of business, because that particular sectoral regulator prescribe particular business form which you need to have if you want to start a startup. Having said that, there is a large area or large number of startup can incorporate it with any kind of a business form, because a large area where there is a no as such prescription that you have to choose a particular business form. So, if you are incorporating your firm as a proprietorship firm, then possibly you do not have any cost for preparation of the document. Similarly, you do not require to have any minimal capital legally required for the proprietorship. So, even you can start your business without any capital or even as low as 100 rupees. But you need to spend some money for other compliances. which I am going to deal it in my next lecture. Other compliances like you might need to go for local registration or registration with the local government. Local government here I mean municipalities, sometimes maybe Nagar Vikas Nigam, sometimes maybe with the panchayats. So, it is depending on who is the local government and who has authority to give you the license of doing the business in that particular locality. Now, there is a different state legislation you will find on these particular thing. Sometimes you will find these particular power given under the Municipality Act, sometimes it is comes under Shops and Establishment Act, so much so forth. It is quite localized. So, if you look into the partnership, in case of the partnership you need to do a documentation in the pre-registration. To be more precise, as I have discussed in my last lecture, that you need to have a partnership agreement, and for drafting of the partnership agreement you need to hire any professional, or even you can do yourself, but it is always advisable that you should take a professional advice, and preparation of this particular document the professional might charge some fees. At the same time, when you are going to take this particular document to the register of the partner, he might ask you to file additional information based on the state laws, and it varies with the different states. And in generally the partnership do not require to have any minimal capital to be mentioned in that particular minimal capital for starting the business. So, similarly, if you are talking about the limited liability partnership, you need to have a pre-formation document, and for preparing this particular document again you need to have a professional advice, and you need to file number of forms. In case of LLP, there is a important filing relating to the designated partner. You need to get partners identification number. So, there is a number of compliance. So, you have some kind of fees need to be paid at the time of the filing also, but there is a no minimum capital requirement in case of LLP 2. So, in case of the LLP, you also require to have required to spend some amount for incorporating a LLP, and to be frank with you, this cost is little higher than the partners formation of the partnership. Now, let me take you to the next category, that is a society. In case of the society, again you need to make a memorandum of association, and preparation of memorandum of association you need a professional advice, and though you are not required to have a minimum capital for the society, but you need to pay the registration fees as well as the stamp duty if it has been prescribed by that state or by that particular registers. But in case of the society, again the fees are not very high. In compare, I think in case of LLP the cost is more than the society. Now, in case of the cooperative, again you need to have a formation document. So, you need to develop the incorporation document, at the same time the bylaws, and there you need to have again a professional service, and you need to incur some cost for preparation of this particular document and filing of these particular forms with the respective regulators. And while you are registering your organizations, again you need to pay the registration fees and the stamp duty. But at the same time, you are not required to have any minimal capital required for formation of cooperatives. Now, please do remember, which I have told you in my last lecture too, that these cooperatives are basically governed by the state laws. So, there might be a difference in the charges. Some state might be higher charges, some state might have a lower charges. Some state have a more flexibility in documentation and filing, whereas in some case some state have a stringent requirement for filing. Some state even restrict some of the business only can be carried out by this cooperative, other cannot be carried out by the cooperatives. The next one is trust. As I have told you in my last lecture too, the trust is not really quite accepted form of business in India, but nevertheless please do use the trust for the purpose of the business. And in case of the trust, again you need to create a trust deed, and in the trust deed for preparation of the trust deed you need some professional services, and then if you are taking the professional services you need to incur the cost for that. In case of the trust, there is a no minimal capital requirement, but trust is always based on some corpus, and the corpus is quite sufficient to benefit the beneficiaries. That means, the capital in case of the trust is quite an amount in compared to other form of a business organization. And for that matter, in case of the trust, again you need to have registration fees, and you need to pay a stamp duty. And in some state, the stamp duty is quite high for the registration of the trust. Again, it is depending on which kind of a trust you are registering. Are you going for a private trust, or are you going for a public trust? The last one which I want to talk with you is the companies. In case of the companies, I have dealt with all the companies together. So, I am going to talk the one man one person company, or limited liability company, or public limited company, non listed as well as the listed. And you need to spend quite a sum for preparation of the formation document or incorporation document of the company. And as I have told you, last lecture also, the company is more of a formal organization. So, in that case, you should be quite careful about the preparation of the formation document or the constitutional document, which is popularly known as Memorandum of Association and Article of the Association, or MOA or AOA, because there you need to put the objective clause, and while you are drafting the objective clause, you should be careful the ambit of the objective clause, because if you have a very narrow objective clause, then you might face difficulty in your business expansion or additional business you wanted to start with your main business. Because if it is not mentioned within the objective clause, then it might fall within the domain of ultravirus. And if it is an ultravirus, then in that case it is not enforceable by law. Then you need to have a capital clause, you need to have a liability clause mentioned in case of the company, because if it is a public limited company, the liability is something different than that of a public or private unlimited company. The last one is the companies, and I have dealt with all the companies together, that is one person company, private limited company, public limited company, listed and non listed. Now, as I told you earlier, that company is a more formal business form. So, you need to be careful while you are drafting the incorporation document or formation document or constitution of the company, that is memorandum of association or article of association, or in short they known as MOA or AOA, because there is several clauses which are quite important, and if it is not been drafted properly, it might hamper your business in the future. One of them is objective clause. I have mentioned in my earlier lecture too, and whatever you mention in the objective clause, you need to carry forward your business within that particular ambit. You cannot do business which is not mentioned within the objective clause. So, if you want to diversify your business, if you wanted to start ancillary business in addition to your main business, then that should be included in your objective clause. You need to have a liability clause in the memorandum, and there you need to mention what kind of liability the member will have in the corporation or in the company. Are you going to go for a limited liability or unlimited liability? You need to mention the capital, how much capital you need to start that particular business, or what should be the authorized capital of that particular company. You need to elaborate the company's function in article of association. You need to elaborate in the article of association about the relationship between the shareholders of the company. You need to elaborate the director's duty. You need to elaborate the internal functional mechanism in AOA of the company. So, to precise, it is bit of a complex documentation in case of the company, and you need to have a professional service for this particular purpose. And to that end, you need to spend some money for preparation of this particular document. I have also mentioned in my last lecture that you need to get a director identification number, DIN, because if you do not have a DIN and you are not mentioning that who is going to be your director in the post incorporation, that means once the company is incorporated, the register of the company is not going to issue the incorporation certificate. So, you need to also choose the name of company, because if you want a particular name, you might not get that particular name. So, you need to give a number of options to the ROC. So, these all this particular thing need some kind of a professional expertise. Though nowadays everything is online, even you can use the searching of the name online, you can file the document online, you can pay the fees online, but doing oneself is a bit of a complexity, and that is the reason you need to have a professional services. Now, in case of regarding the minimum capital, you need to mention in case of the company that how much people are subscribing, while how many shares are subscribing while the company is registering with the register of the company. So, the subscription need to be mentioned in the MOA of the company, and who are the people who are subscribing the shares of this particular company, that is need to be mentioned. So, basically the minimal capital is need to be mentioned in case in AOA. Apart from that, statute emphasis on the minimum capital. Like if it is a private company, then you need to have at least 1 lakh minimal capital at the time of registration. So, the requirement differs if it is a public limited company, requirement differs if it is a other form of the company. So, the statute prescribe that there should be a minimum requirement for a capital, and at the same time, as I have told you even in my earlier lecture, that while you are submitting all the document for registering the company, you need to pay the registration fees, and this is quite a hefty amount. And this registration fees is depend on what is your authorized capital of your company. Bigger the authorized capital, bigger the registration fees. Sometimes you need to have a good authorized capital, because if you want to applying to a financial institution for the funding, then you need to have a good authorized capital. So, to summarize the entire talk, I will once again suggest you that the initial expenditure for formation of the company should be one of the criteria for you to choose a suitable business form. Because if you are choosing a business form where you need to spend more money, then you might find an initial difficulty for formation of the company. So, again I will suggest you that you should have a strategy in place, and you accordingly choose the business form which will be suitable for your business based on the expenditure or the cost which you will incur for the formation of the business. Thank you.